Welcome to our webinar, Improving Your Discovery Risk Profile. I'm Robin Thompson, Scarab Consulting Sales and Marketing Operation Manager, and we're very excited to partner with Access Sciences to host this presentation. We welcome any questions you might have throughout the presentation. Please submit questions via the GoToWebinar chat window or email them to info@consultscarab.com. We'll be monitoring both of these throughout the presentation. I'd like to remind you that this course has been certified in Texas for 1 hour of CLE credit, including 1/2 hour of ethics. As you exit, we'll ask for your feedback so that we can continue to improve our webinars and provide the type of education you're most interested in. And now I'd like to introduce our esteemed presenters, Brian Foster of Access Sciences and Julie Grantham of Scarab Consulting. Brian Foster is the Director of Legal Business Consulting for Access Sciences Corporation. He has over 25 years' experience in litigation support, project management, application delivery, and infrastructure management. He also has proven expertise in designing and delivering litigation support projects to minimize client risk and cost. Brian has managed the discovery processes for several multi-million-dollar cases and several Department of Justice investigations. He is also a member of the American Bar Association. Julie Grantham is the General Counsel of Scarab Consulting, where she is responsible for corporate legal matters for Scarab. She is also an adjunct professor of e-discovery and technology law at University of Texas School of Law in Austin, Texas. She consults with Scarab's corporate clients on the discovery process. She is a member of the State Bar of Texas, the American Bar Association, and the Association of Corporate Counsel. I'd like to turn the presentation over to Julie Grantham. Julie?
Thank you, Robin, and I appreciate everyone being here today and look forward to getting started. On September 9th, as many of you know, Judge Paul Grimm of the U.S. District Court for the District of Maryland issued a very significant decision regarding preservation and sanctions. These are two topics that should be of particular interest to those of you that are attending this webinar, and not only to those of you that are large organizations facing complex issues regarding the preservation of ESI. Now, before we jump in, there are a couple of initial points that I want to make. Please note that Brian and I will both be using the term ESI throughout the presentation as the acronym for Electronically Stored Information, as used in the Federal Rules of Civil Procedure, which many of you know. Also, we've included throughout the presentation various thinking and talking points. Some are rhetorical. But again, please feel free to type in your questions at any time during the presentation. Now, for background purposes on this particular case, Victor Stanley 1 and Victor Stanley 2, the subsequent opinion that we're going to be discussing in detail today, was a suit brought by Victor Stanley alleging copyright infringement, patent infringement, unfair competition, and Lanham Act violations. As we discussed the evolution of the opinion issued from Judge Grimm in Victor Stanley 1 to Victor Stanley 2, those of you on the webinar that are familiar with the line of Zubilate decisions from Judge Shira Shinlin of the Southern District of New York may recognize a similar pattern of behaviors in the analysis. In other words, what morphed from a really fairly innocuous issues regarding cost shifting for the restoration of backup tapes in Zubilate 1 took an eventual pretty harsh turn to sanctions for intentional and willful destruction of emails. But first let's take a look at the facts of Victor Stanley 2. So to refresh your memory if you have read it, and to introduce it to you if you have not, the CEO of Creative Pipe was a man named Mark Pappas, and he, among other devious things, went to Victor Stanley's website and downloaded a laundry list of things, including proprietary design drawings, specifications for office furnishings, specifications for public furnishings such as park benches, park racks, etc. He used the pseudonym Fred Bass to download these design drawings, and used a web designer overseas to help work on some of the designs that he put on his own website. Preservation of information, and in particular to our case today, the sanctions imposed when any party fails to preserve relevant information as we all know, it's been the subject of many high-profile opinions in the ESI arena. But the two that immediately come to mind to many of us are Judge Shinlin's recent opinion this year in Pension Committee of the University of Montreal versus Bank of America, and Judge Lee Rosenthal's here in Houston opinion in Remkus Consulting Group versus Camerata. But back to our issue at hand, once the principals at Victor Stanley discovered what was going on, the company sued for copyright, again, the laundry list that I mentioned. So it's, as seems to happen more and more often, e-discovery matters, as we're seeing, are seeming to take the center stage, and all of the issues that are actual claims and lawsuits are being pushed aside. And this is exactly what happened in this case. So what really began to be the focus was the actual extent to which Pappas had gone to purposefully destroy and overwrite all of these files to delete incriminating evidence before it came to light. So on this slide, I've listed just a few of the many things that happened or that were revealed during the discovery process. A failure to implement a litigation hold, bungled efforts including deletion of internet forms using the pseudonym on Mark Pappas' home computer, and you can read for yourself the other deletion of numerous files, not only on the day of a discovery hearing, but defragmenting of 40,000 files the week before imaging. So in addressing these acts in particular, on page 34 of Judge Grimm's opinion, he wrote, and I'll quote, "Collectively, these acts, they constitute the single most egregious example of spoliation that I have encountered in any case that I've handled or in any case described in the legion of spoliation cases I have read for nearly 14 years on the bench." Ouch. Judge Grimm notes that despite all of the efforts and epic attempts to cover up information, he says, quote, "the countless hours invested by attorneys and experts on both sides, in the end, not much key evidence was lost." So as we can see, Judge Grimm had a tongue-in-cheek approach and dubbed them the gang that couldn't spoliate straight, because any information that was irretrievably lost was at the end of the day acknowledged as prejudicial by the defendants. So how does this apply to the people that are on this webinar, and how does this apply to others that aren't on this webinar but may be watching it at a later date? As counsel, you should be advising your organization of their preservation responsibilities. This could happen under your watch. How much control do you have over your employees? So why is this case so memorable? Yes, there was a default judgment on Victor Stanley's copyright claims. That's not quite so memorable. But what was memorable was Judge Grimm ordered the principal of Creative Pipe, Mark Pappas, to be imprisoned for up to 2 years until he was able to pay the attorney's fees for Victor Stanley's prolonged efforts to investigate and demonstrate Pappas' spoliation. So in the end, and to add another chapter to this saga that I don't have anything on the slide because it occurred 10 days ago, on November 30th, on the defendant's appeal, the district court judge declined to adopt Judge Grimm's order regarding incarceration. And the district court specifically said, the court does not find it appropriate to order defendant Pappas incarcerated for future possible failure to comply with his obligation to make payment of an amount to be determined in the course of further proceedings. Certainly, if defendant Pappas should fail to comply with a specific order, the court may issue an order requiring him to show cause why he should not be held in civil contempt for failure to comply with that payment order. Also, under appropriate circumstances, criminal contempt proceedings might be considered. So, as you can see, the court upheld the magistrate judge's order and recommendations in all other respects. However, and they did order, and the district judge did order the defendant to pay $337,000 and change as a sanction for bad faith spoliation. Again, think about if this could happen to you in your organization. We certainly have not seen in this arena of electronic discovery criminal charges being brought. This is really a precedent-setting case at this point. So thankfully for us, Judge Grimm does provide, in this opinion, a broad survey of preservation and sanction law. If you do read the opinion, he notes on page 36 and 37 of the opinion that recent decisions have generated concern regarding the lack of uniform standards that govern preservation and especially spoliation issues. In sum, what he says is that decisions imposing strict liability for the loss of evidence are being made. And as many of you know and have suffered from, they're being made without adequately taking into consideration the difficulty of preserving ESI. So we're all indebted to Judge Grimm, if he's out there listening, for his in-depth discussion of the issues and also for offering, if you've seen the opinion, the concise appendix that shows the scope of duty to preserve and spoliation sanctions by the circuits.